Should we go ahead and get started? Okay. All right, welcome everybody. I'm Scott Firkin. I'm the Executive Director of the Louisville Bar Association, and it's a pleasure to welcome you to our webinar today, which has to do with Healthy at Work, some practical suggestions and considerations for reopening your law office. Our panelists today include Todd Logston, who is an attorney at Fisher & Phillips. He's part of the firm's COVID-19 task force, which is a cross-disciplinary team of attorneys that's dedicated to advising employers on many workplace law aspects of this global coronavirus pandemic. And Todd is a U of L law school graduate who's admitted to practice in both Indiana and Kentucky. Also joining us today is Amy Olds. Amy is an HR consultant with HR Affiliates, a Louisville-based HR consulting and outsourcing firm, and she works with clients in a variety of industries, providing strategic and tactical HR support. Over 20 years of experience doing that. She has a bachelor's degree from Morehead State University. And last but not least is our good friend, Gladys Smith. She is the law office manager for McMaster's Keith Butler, a local firm that represents doctors, hospitals, long-term care facilities, and other healthcare providers in civil suits and administrative proceedings. Gladys has over 25 years of experience in law office management and is active in the Kentucky chapter of the Association of Legal Administrators, a good friend of the LBA, and we've done some joint projects together. So thanks to all our panelists, and welcome to all our virtual attendees. This is the actually fourth in a series of free webinars that the Louisville Bar Association is putting on. The first three had to do with the impact on various courts. We did one on trial courts, and then the following week did one on the appellate courts, and then just concluded one last Tuesday on family courts. And we'll have one next Tuesday, May 26th, same time, 2 p.m., that has to do with district court and how those operations have been impacted and the adjustments that have been made. But today, our focus is getting back to work because the time is nigh and many businesses are beginning to reopen. So with that, I'd like to turn it over to Todd and ask him to give us some of the legal and HR considerations as Kentucky employers do get back to business.
Thanks, Scott. Well, good afternoon, everybody. My presentation, I did my best to pare this down from about an hour and a half presentation to roughly 15 minutes. Scott promised he won't have me on a stopwatch. So some of this is going to be kind of high level. My contact information is at the end. If you have other questions, feel free to shoot me an email or give me a call. Probably the main thing I want to say is this stuff changes every day. I mean, we've been dealing with this since March on lots of different facets. And if you've kept track of it, you know the advice from the CDC can change daily. What comes out on Monday might be contradicted what comes out on Wednesday. So you really do need to, bookmark those pages, the CDC, the governor's webpage, and the Healthy at Work, and check on those daily. I can't stress that enough. So where we're at is on April 29th, the governor said on May 11th, these industries would reopen. Professional services, which would include law firms, could have reopened last week at 50% capacity. I know some firms have, some have not yet. We are awaiting some PPE and signage before we change from telework to being back in the office, at least part way. Some of the other deadlines we've got coming up are on this slide. I stole these from the governor's webpage. I think these are mostly up to date. I think churches may have already opened, but the rest of these are pretty solid dates. So Healthy at Work is the name of the initiative from the governor's office. And right now, the most recent and important executive order is 323. And what it did is, if you hadn't already seen it, there were minimum requirements for all businesses, and then they're putting out industry-specific requirements. And those are being adopted into this executive order. And that executive order, I think, came out late Sunday night, May 10th, because I checked it last about 10 o'clock that night, and it was there the next morning. So we were questioning, well, are the minimum requirements or suggestions? And they are now, in fact, requirements because they're in the executive order and they have the force of law. We're going to go through some of the highlights of the minimum requirements, but I would encourage you to go to the Healthy at Work webpage and pull those up for your industry, especially too. So for law office or for office operations, there's a whole set of requirements. The other thing I wanted to point out to you is the Kentucky Safer, both online and by phone. Anyone can report any non-compliance with any business who's not following the minimum requirements or the industry-specific requirements. So that could be your employees coming back. So if you don't agree with some of the information that's in the executive order, or you think it's overblown, just keep in mind that all of your employees may not agree with you, and there is a venue for them to call that into the administration, and you could get a visit. And we'll talk a little bit later about what Kentucky OSHA's involvement with that has been. Again, stole this from the governor. This was something they were putting out with their 10 rules to reopening. I would tell you now that the minimum requirements are 14. So we'll hit some of the highlights of those. If you're not already aware, you have to designate a safety officer or a return to work, Healthy at Work officer, I think is what the name of it is now for your workplace. There's a requirement that says require employees to telework, and I've put must in parentheses there because the language of the order says, or the minimum requirements that's been adopted into the order says employees who are able to telework must telework. Now, that doesn't really jive with the allowing professional services and offices to open at 50%. So we'll see how that plays out. My advice to clients is since you have a must telework and up to 50%, at least up to 50%, I would let some employees who are uncomfortable with coming back to work, if they are able to telework and they're able to be productive, maybe consider letting them continue to telework instead of forcing them. That might be the employee who calls the Kentucky Safer line upset. Employees must wear a cloth face mask if they're going to be within 6 feet of others. They don't have to wear one if they're alone, like if they're in their own office, or if they're going to stay more than 6 feet away. And that was a nice reprieve because the first set of minimum requirements didn't have that within 6 feet. It just said everyone wears a mask unless you were, enclosed in your own office. The other thing I would tell you about that is the employers are required to provide those and required to train employees on the use of them. So you want to make sure you're looking in that information and you're doing that. You have to conduct daily temperature checks and employee health checks. Now, the nice thing, I say nice thing because it changed a little bit, is that the employer doesn't have to physically do those at the workplace. You can allow employees to do that at home and then just report that they've taken their temperature and they've answered those questions that are in the order and that they're good. So I have some clients who are providing that information, making sure everyone understands what they have to check. And then as they come in, they give a thumbs up or a thumbs down. And they're told, if I have a fever over 100.4, or if I answer yes to any of these questions about a cough or some of the other symptoms, that they don't come in, they call. And if that changes the time they get to work, they give you the thumbs down, and then you're going to redirect them somewhere else. You have to have a testing plan. I think the most recent iteration of that says that to get employees tested within 36 hours, which is a little better because the one prior said immediate. So within 36 hours, and at that point, as the employer, you can't force somebody to take a test. You can't physically take them to get the test. I think what you can do is you direct them to either go to their healthcare provider or to one of the testing centers and get that test done within 36 hours, and that they're not allowed to return to work until that's been accomplished. There's also a part that says to have special accommodations for those at greater risk to the greatest extent practicable. Now, that phrase is throughout that order and the minimum requirements multiple times. At this point, there's no official requirement to give additional leave or paid leave or anything like that. But it is an indication that you ought to think about if you've got somebody at high risk about whether you're going to let them come back to work or not. We'll talk about some accommodations that are actually required by other laws a little bit later here. You have to have a plan for contact tracing and work with the health department. And basically, you're going to provide information when requested from the health department. And then employee training on everything you're going to do to to meet those minimum requirements and your industry-specific requirements.
Okay. Todd, if I can interrupt for just a moment, I'd like to ask either Gladys or Amy regarding the point about employers needing to provide the masks, the PPE. I've heard some stories about challenges that people are having in acquiring things like the masks, the hand sanitizer, the plexiglass shields, those things. Gladys, have you encountered any of those difficulties, and do you have any?
I've been fortunate enough to be able to get those supplies. I've sent Marissa some information about Commonwealth Technology, who can supply the mask. There's a K95, and then there's the 3-ply. Depending upon when they order those, they can get those in 3 days. So I've provided her with that information. There's a facility, Flavorman, up the street on 8th Street, has the sanitizers. So I've not had difficulty yet.
Okay. And that's a good chance for me to mention to our participants that at the conclusion of this webinar, we will be sending out or actually placing on our COVID-19 update page on the LBA website this information that Gladys is referencing. So those resources will be shared with you as well. And Amy, I was wondering from your standpoint, if you have encountered requests from employers for help in the training aspect, training the employees how to use this stuff and which protocols to follow.
Yes, we've had lots of questions regarding that. And really, most of the time we're directing them to the CDC website because they have videos that will train them on the correct wearing of the PPE. So we're providing links in our appendix of our action plans for COVID. So that's definitely been a question, but the CDC has been the best resource that we've been sharing.
Excellent. Okay, Todd, that kind of leads into your next point about employee concerns. So please continue.
Yeah, thank you. Yeah, I think you should expect you're going to have varying opinions from your employees about coming back to work. I think some folks will be fine or ready to get back to work. And some folks are going to be very worried, very anxious. And that's probably going to vary depending on what's going on in their life, whether they are in a high-risk category or somebody in their household is in a high-risk category. I think one of the best things you can do is provide some clear explanations of what you're doing as an employer to comply with the CDC requirements, with OSHA requirements and guidance. I say CDC guidance and OSHA guidance and requirements, and the Healthy at Work executive order. I think for a lot of your employees, that will lessen some anxiety. So you should be prepared to explain that and to answer questions. And that's what that Healthy at Work officer or safety officer is supposed to be prepared to do. OSHA has not issued any new regulations or standards related to COVID-19. They have issued a lot of guidance. A lot of that incorporates the CDC guidance. My recommendation for our clients anticipating future litigation is one of the best things you can do is to stay up to date on the CDC, the OSHA guidance, and whatever the current state is of executive orders for your state or your location, and to be complying with those and to document how you're complying with those. So later, if there's any kind of litigation, either from employees or from customers or the public, you can prove what you did to act reasonably and to prevent. I have on here enforcement by COSH, that's Kentucky OSHA. I will tell you, as of right now, they're conducting all of their inspections remotely. That means they're calling you up on the phone, they're having an opening conference on the phone, they're asking for documents via email, they're doing all the interviews over the phone, and they're not coming out. And that's even for fatality investigations. I have several of those, and that's not unique to Kentucky. Indiana OSHA is doing it, federal OSHA is doing that. So you probably won't receive a knock on the door right now. I think that will start to change in June as government offices reopen. You'll start to see more visits from OSHA. The other thing I have on here are shutdown orders. Prior to the May 11th order, Kentucky OSHA was enforcing the executive order about essential businesses and social distancing, and I've actually had clients whose facilities were shut down. So what happened there is an employee or somebody else had called the Kentucky Safer number. Somebody from OSHA shows up, they observe people not social distancing, and they hand them a pre-populated cease operations order. Then you have to work through the labor cabinet to get reopened. And we were able to get everybody reopened in either a day or two. But that's a big hit to your business to be shut down for a day or two unexpectedly. My understanding going forward is that the health departments are going to be more tasked with this than OSHA. I think OSHA is being overwhelmed with other complaints and inspections as more businesses come back online. So I think you could expect either OSHA or state or local health department. Here in Louisville, it will be the Metro Health Department accompanied by Louisville Police if needed. It's a misdemeanor, so somebody gets to go and stand in front of a judge or be videoed, and it can be up to a $500 penalty in addition to actually being shut down. So there's a hierarchy they'll go through of giving you a warning, which is another improvement from what the prior situation was. You got a visit and you got shut down. Now they're going to give you a deficiency notice, let you know what things you're not doing correctly. As long as you fix those, everything should be fine. If you don't, or you continue to get complaints, then there's going to be some penalties and then a shutdown order. So if you want to avoid getting shut down and penalties, then you want to make sure you're doing your best to comply with the governor's executive order.
Todd, do they shut you down immediately, or do they come in and give you warnings?
What they had been doing prior to May 11th was just showing up, and if they observed deficiencies, you were shut down. What I understand they're going to do now is if they show up, or they may even call to let you know about it, then they're going to give you a chance to fix it. If you don't fix it, then the next step is to be shut down, potential misdemeanor, and penalties. So if you get a visit from them, even if you don't agree with the governor's executive order, and I know opinions vary, if you want to stay open, you need to be complying with that and making your workplace as safe as you can per the CDC and OSHA guidelines.
And Amy, I wanted to interject a question for you. Todd referenced a moment ago that some employees are going to have some anxieties about returning to work. From an HR perspective, how can employers effectively address those concerns?
Well, it's like Todd, and that's a great question. It's like Todd said, with all things, you want to be proactive with that. So, if any of your organizations have an EAP, an employee assistance program linked up with your benefits or separate, that's a good thing to share with your employees. But the one thing that I've been sharing with all our clients, as we've said, this is changing daily, but flexible is the key. So we've had broad questions of, whether or not, what do I do if this person is, has an issue? And we really are encouraging you to take it on a case-by-case basis, because some people may have situations where they're protected under the ADA. It could be an accommodation situation, as Todd mentioned, or it could just be generalized anxiety, which kind of goes back to how I've been enforcing, really solid plan with how you're going to keep your employees safe during this time is key, and the communication of that plan.
And I also have heard some concerns expressed by, working mothers or fathers, because if I understand it, daycares upon which these folks rely heavily are not going to be reopened on the same schedule. So how would an employer address a situation where an employee is otherwise ready to return to work but can't because of childcare issues?
Well, if they can still work at home, we're recommending that they can, continue to work at home. If they cannot work at home and they're still an active employee and they've not been furloughed or laid off, the FFCRA it would be helpful for that, the emergency family medical leave that will allow employees either on an intermittent or a long-term basis up to a maximum of 10 weeks to get 2/3 of their pay while they're helping with childcare issues. A lot of my clients have had employees that are using it on an intermittent basis. So they're working with their spouse or significant other, and working 3 days a week. And so, but the FFCRA would definitely be a solution if they can't work from home.
And Amy and Scott, we've got all of our support staff and attorneys able to work from home remotely. It's if they're sitting at their desktop and communicating with the client like they're in the offices. So several of them have children and they're working remotely and sharing the time with their spouses, if the spouse may be there one day and that maybe they might come in. But for the most part, all of our attorneys have been working remotely from home without issue. Partially the staff being here to support them in the office when need be, but also the staff have the access to work remotely because they have childcare issues, like with the schools. The schools are still in. So we're flexible with our employees and we are not demanding that they come in, especially if they feel uncomfortable. But we do allow them to work remotely and come in when they can and when they feel comfortable.
Okay. So it sounds like flexibility and communication are two key words during this time.
Yes, 100%.
Okay. Todd, I didn't mean to knock you off stride there. I think you have some information for us regarding workplace privacy.
Yeah, no, and I totally agree with what both Gladys and Amy said, and I think Amy's answered the questions I have later on Family First Coronavirus Response Act, so we'll be able to skip through those. So privacy, this is going to come up if you're doing the daily questionnaire and the temperature checks at work, or if you're simply dealing with that you have people who are testing positive or have symptoms or have been exposed to people. And you need to keep in mind that businesses and individual supervisors can be held liable for defamation in Kentucky. There's multiple different ways you can defame somebody and be liable. The most probably relevant one here is imputation of a loathsome disease. And I guess we would say COVID-19 is considered a loathsome disease, or at least there'd be an argument that is. And that can be presumptively slanderous. So you want to be careful not to discuss that. And probably if you're an HR person or a legal administrator, you know that. You might want to talk to your attorneys and make sure they know that, and any other management staff, make sure they keep that in mind. In addition to defamation claims, you also have to keep this information private and confidential under the ADA. You want to keep records separate from personnel files. Only those who have a need to know are involved in it. That usually is going to be HR. The GINA Act, the Genetic Information Non-Discrimination Act, also may come into play. HIPAA can come into play, but for most smaller employers, it's not going to. That's usually going to come into play for healthcare providers, unless you're self-insured or something like that for health insurance. But basically, the general rule is everyone doesn't need to know that Todd was coughing today and might have the corona. Right? So let's keep it quiet. Let's keep it professional, like you do with everything else.
I do have a question about the temperature checks. Should the employers be conducting these, or is it sufficient to ask that the employees do it themselves and report the results? Do you have any advice about that?
I do. I can tell you what the law requires right now. Neither OSHA nor the CDC necessarily require that the employer do it on site. The governor's order allows that it can be self-administered by employees at home and report it, but there is a requirement to do it. So I think you have to make sure you're capturing it. I think if you're going to allow employees to do it at home and tell you about it, you need to stress the importance of you actually have to do this, and we're expecting you to report this in. And I'm probably talking to the guys more. That we generally don't like to go to doctors, and we don't want them to take our temperature and that kind of stuff. But I think you want to make sure employees understand, if we find out later that you've lied to us, that you didn't take your temperature, that you really didn't give any thought to these questions, and you lied, and especially if there's symptoms, we're probably going to have to take some type of an employment action against you down the road. So I think you need to make it, stress it to employees. You've got to do this. If you're going to do it on site, then, and there's some benefits to having the employees do it. It's actually a little bit safer. We hope it's accurate, but it's a little bit safer because you're not exposing somebody else to taking that temperature. But if you choose to take it on site, then the person taking temperature needs to be garbed up with the appropriate PPE. That's probably going to be gloves, maybe a smock or a disposable gown, at least a face mask and goggles or a face shield. And you want to use the no contact type of temperature taking. Another option is to allow the employee to take the temperature themselves and show it to the screener or the person who's standing there, but they still need to have the appropriate PPE on. But they'll be able to maintain a little bit more distance from them as opposed to, putting that on their feet.
So I thought we weren't supposed to keep a record of the recording, just if we give them a level that it should be up or down. Are we logging the temperature level?
My recommendation is not. So even if you're taking the temperature at work, there's not a requirement that you keep a record of it. Now, in the FAQs from the governor's office, they recommend that you might want to do it because it might be helpful later for contact tracing. I don't think that that's really when I weigh it out, it's not worth the risk. If you start to keep these records, then those are going to be confidential medical records under the ADA. They have to be kept separate. Also, probably not taking the temperature, but the health questionnaire is arguably a medical record under OSHA regulations. And there's a regulation that would require you to keep any medical record like that of an employee for the length of their employment plus 30 years. So if you don't really want to get into keeping these kind of records, I would try not to do that. And that regulation from OSHA about keeping stuff for 30 years after somebody leaves was never intended for this. It's intended for exposure to chemicals that had some type of a latent effect where somebody might get cancer or something, far down the road. But there is an argument there that it is a medical record. If you treat it as a medical record under the ADA, it's hard to say it's not a medical record under OSHA. I've got some employers who, there's a wide span. I have some employers who have thermal scanning cameras that you walk through and there's a green or a red light that's only visible to the screener. And then the person either goes left or right after that. Other employers are going to have people do this at home. They have a form that they sign that they've been trained on what they have to look for. And then when they come in, there's a screener there and they give that thumbs up or that thumbs down. And then some clients are just keeping like an attendance sheet that, that was a yes or a no, that they said, yeah, I'm good on symptoms. So there's a wide variety of things an employer can do. And I think you have to figure out what works for your work site based on the type of work and how large you are.
Our plan is, and we've ordered one, is the self-testing monitor that you just put it on your forehead, and we're planning on allowing our staff to do their own temperature check and just say good or bad. And then at that point, my question to you would be, if the level is up, is that when the questionnaire comes into play, or does the questionnaire come into play every time they come into work?
Yeah, the executive order separately talks about temperature taking and a daily health check. So I read that as that questionnaire is an everyday thing too, because that's when you're asking about symptoms, about cough and being tired and all that kind of thing. And keep in mind, somebody could have a fever and not, certainly not have the coronavirus. Some people just run a little bit hot as it gets hotter. If somebody's hustling from the parking garage into the office, get that heart rate up a little bit, they may have a bit of a fever. So the fever in and of itself at 100.4 or more doesn't mean they have the corona, but I think that with the questionnaire might be, if it was just a fever and they said no to all the symptoms, I would say, well, why don't you step off over there, cool down for a little bit, let's try this again in about 5 minutes. Then if it was still high, then I would say, hey, why don't you go back home and call your doc and just make sure that you're okay before you come back. Again, just having a fever doesn't mean you have the coronavirus. Even if you have the symptoms, it doesn't mean. But all those things taken together are an indication that somebody might have it, or at least might be symptomatic of having it, and they need to get checked. So
you would go through the questionnaire for the day and then check off that the employee checked okay, and then not keep any record other than the employee checked okay and answered the appropriate questions in the questionnaire.
Right. Yeah. The employee gives you a thumbs up that I said no to all of the questions on the questionnaire and no to, do I have a fever of 100.4 or more?
And this all goes to the employer's obligation to provide a safe workplace.
Yeah. Under OSHA for a safe workplace, and under the governor's executive order where you're specifically required to do this.
Right, I think you had some tips for us regarding human resources, some considerations about sick leave and such.
Right, and as Amy pointed out, if you have under 500 employees, you're arguably going to be covered under the Family First Coronavirus Response Act, unless you're in the healthcare field where you can be exempted. But I'm assuming everybody on the call here is a law office, so you wouldn't be exempted. If you're under 50 employees, then you may be exempt from the expanded Family Medical Leave Act that Amy mentioned, where you can get 2/3 pay for up to 10 weeks for childcare issues related to COVID. So the school's closed or daycare is closed. That first 2 weeks, the first 80 hours, though, under the FFCRA is the emergency paid sick leave, and that can be at 100% of the regular rate of pay or at least minimum wage if they've been quarantined, advised by a healthcare provider to stay home, or they're having symptoms and seeking treatment. And then at 2/3 of their pay if they're missing for childcare for up to 80 hours, the first 80 hours, and or if they're caring for somebody else who is symptomatic. So you do want to make sure you're checking on that, especially if you're under 500, or in make sure where you fit if you're under 50 to be exempt. You remember, you're not going to be exempt from all of it, just the emergency or the expanded FMLA.
And I wanted to speak to the exemption, because I've had our niche size is, between 5 and 100 employers. So I've had a lot of questions, or, can we be exempt? And I read through the Department of Labor guidance on the FFCRA, and right now, today, it looks like it's going to be pretty hard to qualify for an exemption. I can't recall the specific language, but it did refer to, pretty much kind of financial ruin, if you have to do this. So, before you say, well, I'm under 50, so I should be exempt, really explore that, reach out to your HR or attorney resource before denying somebody that leave.
That's a great point. It's not just a simple I'm under 50 threshold. You're right. You have to show that it's going to substantially harm the business or the future of the business. So that's a great point, Amy. The rest of the stuff I have here on the slide is that under the executive order, there's no new entitlement created for leave or paid leave. There is a request that employers are encouraged to be as flexible as they can, especially with those in high-risk areas. If they had sick leave that they had earned prior to you shut down, that needs to be restored unless they've used it or it was cashed out or something like that. So I think Amy or Gladys, both, either one of them said something about being flexible. So whatever benefits you provide to people, normally, whether that's PTO or sick time or personal leaves, I would be prepared to provide that to employees now, especially if they are in a high-risk category, somebody in their household is in a high-risk category, and maybe if they're just anxious about coming back. And one of the other speakers pointed out, if you could let them telework, they were able to do that before, you might want to consider letting them continue to do that at least as much as you can. Obviously, some jobs that just doesn't work, but for office-based work, attorneys especially, that's worked out pretty well for most attorneys. I think I duplicated a slide here. Sorry. That's the downside of attorneys working from home at night trying to put their own PowerPoints together.
You've done a great job.
This is just a little blurb off the DOL webpage about Families First Coronavirus Response Act. I think we've talked about that. Unemployment benefits in Kentucky. I'm sure everybody's heard of the enhancement by the federal government. But once you start to open back up, if an employee refuses to work when work is offered, they are only going to be able to keep getting unemployment benefits if there's a valid qualifying reason that for them refusing to return. And that's going to be something related to COVID and not child care. There's about 8 items in the CARES Act from the federal government that say what's covered. So just general anxiety about not coming back may not work. If they have a doctor telling them they need to stay home, that might work. But if you've had folks furloughed, when you contact them about coming back to work, they're going to have to fit into one of those valid qualifying reasons, or they're going to risk losing those unemployment benefits. Now, at the end of the day, whether an employee gets unemployment benefits isn't the employer's call. You can contest their application for them, but ultimately that's going to be made by the Unemployment Commission. But you might want to let employees know, hey, I have to send this report back in, and if you may be asked, and if that's not going to be a qualifying reason, they're going to stop your benefits. And the additional from federal stops at the end of July. The other thing I want to talk about was work comp. I don't think it applies, to law firms necessarily, but the work comp laws were changed a little bit by an executive order that said if an employee is removed from work due to an occupational exposure, then temporary total disability benefits are going to kick in immediately, no waiting period, and that's payable even if you later deny the claim for employees who are in sort of that frontline work, healthcare, emergency response, death care, that kind of thing. Probably not an issue for law firms, but did want to throw that out there.
Okay. And Todd, I have heard of sort of a tension that's developing because some of the employers received the SBA PPP loans, which, as I understand, are forgivable provided that the funds are used to employ staff. So there are some employers who are motivated by that to have employees return to work, although the employees may feel that that the workplace is not safe or that they're not ready to return. Have you heard of that? And what would you say about that situation?
I have, yeah. So under the CARES Act, part of that provided the Paycheck Protection Program loans. Again, have to be under 500 employees, including all of your affiliates. And it can only be used for allowable cost. One of those is payroll costs, and that's a broad definition of payroll cost. But in that 8-week period after you get the loan is the amount spent during that 8-week period on allowable cost is what's potentially forgivable. Our advice to clients is don't expect it to be forgiven. Some of it might be forgiven. I think the chances most employers are going to get 100% of that forgiven are slim and none. Okay. Our firm, we're all over the country. We have 35 offices, and some of our offices have dealt with similar programs after other emergencies, for example, Hurricane Katrina or some other hurricanes. And with similar programs, what they've seen is the money goes out pretty easily, but when you ask for forgiveness, that's when the SBA is going to be very persnickety. They're really going to scrutinize your records. And basically, somebody's job is probably going to be to figure out some way to not forgive 100% of what you're asking for. But if you've gotten that loan, you have to spend it in the 8 weeks on those allowable costs. So if you hold it and you're not bringing people back, those costs aren't going to be forgiven. So the employer, if it's allowed otherwise under an executive order and it's safe, you can require employees to come back. You can pay employees not to work. But if they're already getting unemployment, they can't get both. If you're counting it as leave under the Family First Act and taking the tax credit there, you can't also use that PPP money for that. So you do really need to look at that. That's a whole nother webinar that's probably a couple hours. You do need to look at which pot you're sort of pulling that money out of for the tax credit purposes. That the government's real big on you can't get tax credits on top of tax credits. But if the good news for the employer is if you don't spend all that money at the end of the 8 weeks and you're worried about what's going to be forgiven or not, it's still a pretty good loan. It's 1%, it's 6 months deferred, and you got a 2-year term to pay it back. So it's not the worst loan in the world. But the other thing is if you don't want to take that loan, there's no penalty for prepaying that and paying it back. So if you're an employer and you're worried about, hey, I can't get my employees to come back to work during this 8-week period to use these PPP loans, that's okay. You can just simply give the money back, and you're only going to pay whatever interest has accrued during that small amount of time if it's not later forgiven.
Okay. Thank you.
No problem. Okay, so this is where I just have some practical considerations, kind of a summary, and I'm sure Gladys and Amy have some things to add. But you need to start trying to obtain those face coverings. I think we talked about that. Gladys gave some great tips on how to get that. Be ready to either take temperatures or to have a plan in place for how your employees are going to take it and how you're going to capture that's happened. Know how you're going to handle positive cases, exposures at work, and potential exposures. You're going to need to follow the CDC guidelines. If you're coming back online now, you're probably not going to be one of the essential businesses, so you're not going to get some of those exceptions. So you're probably going to be looking at sending people home. So make sure you're up to date on what I'm going to do with that. Be ready to enforce proper hygiene and social distancing, having the barriers put up, marking the floors. Your halls are one way. Maybe you're limiting your bathrooms to one person at a time. all of that stuff that's recommended by OSHA and the CDC. And I think there's some additional information in the executive orders and the industry-specific guidelines that you can follow. Be ready to calm employees' fears. And I think Amy talked a lot about that, about communication and flexibility. Know how you're going to handle and recognize and handle what I call PCA, but that's protected concerted activity. So if you have an employee who says, we think it's not safe, and I speak on behalf of all employees, that's something that you're going to have to deal with the National Labor Relations Board on, and you want to know how you're going to handle that. The same thing for OSHA. There's some protection for employees who believe that in good faith that it's unsafe to do a certain task or to return to work, and you can't just say, well, I said so, so you're out. That could probably get you a violation from OSHA. So my recommendation on both of those is that you explain everything you're doing, why it's safe, listen to them, give the employee a chance to change their mind. But at the end of the day, if you're confident it's safe and you think they're not acting in good faith, you can suspend them, and then you probably need to talk to Labor Council before you make any permanent decisions there. Be prepared to permanently adopt teleworking. You may have some employees that's going to be their new normal for a long time is to telework. We have an employee in our office who is really a sort of a corporate employee that works on billing and collections. She doesn't really have to be in our office. She's working great from home. She could work from any office in our firm. She may decide to stay doing that. You need to be prepared to do that. And then temporarily at least have lenient leave policies. Even if you're just letting the person have unpaid leave, as long as make sure you're not getting running afoul of your healthcare providers' requirements for being employed on a certain regular hourly basis and a certain number of hours. But if you're not doing that, you might give some people some extra time to take leave and be off. They're in this really weird time that we're all dealing with right now.
Well, those are some great suggestions. And I'd like to ask Gladys, just in terms of your own workspace, work environment, how are you, what accommodations or what preparations are you making for people who will be back in the office?
Our office is a private office. We have the whole 5th floor at the Beulah building, and it's locked down. The only way you can gain access to our floor is using the call box downstairs. We're able to selectively choose who comes up to our floor. Right now, we're only getting delivery people, and they're masked and gloved down. When we arrive in the office, we wipe the common areas down daily. They're also wiped down in the evening when we leave with our cleaning people, but we also go back through in the morning and then clean those same common areas. We have the disinfectant located strategically in all the common areas with the hand soaps in the restrooms and the sink areas. So we make those available for anybody that is using the copiers, any of the tools or staples. So we make sure that those things are provided so everybody can stay clean. We're asking people when they're using any of the areas to wash their hands on a regular basis and to clean the areas that they're working in on a regular basis. Even if they didn't work in that area, if they see that it needs to be wiped down, please wipe it down. We have about 11 employees. And so we're small, we're able to maintain cleanness of the areas. We provide gloves to wear for anyone that comes in the office. We've ordered personal cloth masks, which we just received, and each employee has their own mask to maintain. We've ordered the additional 3-ply masks, up to 100 in a quantity for anyone that visits our office and for the staff to use if they've left their mask. We're not making it mandatory, but we're asking them to be aware of the social distancing, and if they need to stay in the office and close their office doors to do their work, fine. We've kind of been privately in one area with a minimum of 3 to 4 people. So we're just now bringing in a few more people to work in the office areas, support staff. So again, we're just trying to make sure we provide all the tools. The temperature control device that we will have to use on the forehead will be arriving soon. So we'll set up our policies based on what Todd has told us, and log that information going forward.
Okay. What about common areas? And this is really for any of you, like break rooms, kitchens, shared bathrooms.
We don't really socialize in the conference room anymore. Everybody's kind of in their own office area. We used to have lunch together. We don't even do that anymore. We don't have a lot of people going to the restrooms together. So I think we've kind of, being small, that's not an issue for us right now. We don't have a crowd of people going in the restroom. So we are aware of social distancing in our office. So that hasn't been a problem for us yet.
Okay. I had a question regarding, and maybe Todd can answer this one, the number that you gave out, the Kentucky Safer, where reports of noncompliance can be made to the state. Are those reports confidential, or does the reporter have to give his or her name or reveal their identity?
The way OSHA would normally handle that is that's going to be confidential. They can choose not to give their name to OSHA, and I'm not sure who's answering the phone there or getting the emails. I know OSHA has been coming out to enforce the executive order. I think it's going to be health departments now. But generally, they have an option to do that anonymously, or if they give the name, it's still normal OSHA practice would be that that's kept confidential, that the employer is not going to find out who that is. And to the extent that does run through OSHA and you're the employer and you think you know pretty well who it was, be very careful about taking any action against them. I think you would set yourself up for retaliation claim under OSHA.
Very good.
And we do recommend for our staff also to wear their masks in public places. We're not with them 24 hours, but it's recommended.
Okay.
I did want to add with the common areas is that several of my clients have actually shut down their break rooms and removed access. Definitely things like coffee pots, any of those types of shared items. If you have the water coolers or the containers, to go ahead and close those down. Anywhere where people gather, the foyer or the front area. And I believe Scott mentioned this, but signage is really key, because you could get people back in the office and it's kind of easy to forget that, what you're supposed to be doing, by the copier, then. So OSHA and the CDC have a ton of great signage out there, free and available to download so you could put up around the office.
Okay. We've had a question from one of the viewers regarding changes that need to be made for clients or potential clients who come into the offices. What precautionary measures would be appropriate for folks coming in from the outside, so to speak?
Like Gladys had a plan that they're using. Maybe she wants to talk about that.
Clients coming in, well, we measured our conference room to see how many we could accommodate being the 6-foot distance, and we can barely get the 4 in our one conference room. We don't have any clients coming in just yet, but we're looking at, if we did, we could only accommodate so many people. And as I said, it's almost less than 4. And we probably wouldn't bring anybody in beyond that. Most of our meetings have been, like, we've got a mediation coming up. It's going to be via the internet. So I think we will continue to do that until we have other options.
I know, speaking for the LBA, this May and June would ordinarily be a really high season for us to have a lot of people in the bar center because of the June 30th CLE deadline, which of course has now been relaxed by the Kentucky Supreme Court. But we were talking about when the day comes when we are able to have live seminars emanating from the bar center, the same sorts of considerations. How to maintain social distancing, what's going to be the new capacity of our seminar room? And, what do we do with respect to, I guess this is a question for you guys. If we have a visitor coming in who objects to wearing a mask, even though that might be our requirement, what right or recourse do we have to refuse them entry, or how do we deal with that situation?
The executive order does say that you can refuse entry to a customer who refuses to wear a mask. I think unless the mask creates a safety and health hazard for them. So other than perhaps a public accommodation issue with somebody who is really unable to wear a mask, I think you can refuse entry. If somebody refuses and claims some type of a public accommodation, you're really that's a tough spot to be put in, because it's not going to be obvious that the person's not visually impaired or hearing impaired, and you don't know if they're telling you the truth about whether they really have a health issue or not. But short of that, I think you can deny entry. It is your real estate, your workplace, your property.
Okay.
And I think the best defense to that always is to try and be as proactive as you can. If you can't control the flow, to put that expectation out there. So when we get to the point, we're still conducting all of our meetings virtually. We're not going on site to visit clients yet. But when we start having people come back into our office, I know that we will be letting them know what the expectations are so that we can address it before they hit the door.
Okay.
And Amy, you talked about common areas and places where you offer coffee, water, soft drinks. Those areas that are clean on a regular basis. If we are a small office, we don't have a lot of people. Is there some way you can kind of get around that by maintaining cleanliness or wearing gloves?
Yeah, and depending on the space, you can. I think you have to take an assessment, a risk assessment of that space, and what do you want to allow. I know my husband works for a large company, and they have multiple floors, and they have closed their break rooms completely closed. When you're smaller, you could. One thing I've seen is, it's just the microwave. You're allowed to use the microwave, and people are having people bring coolers in, so if they want to bring their lunch or something, they're bringing those coolers in. But it's really best practice to try and eliminate as many frequently touched surfaces by people. If someone needs to go in and use the microwave or maybe grab a paper towel, I just suggest, depending on the space, one at a time, type of situation, and definitely not to linger and eat.
And those are areas that we wipe down constantly. I'm fortunate enough to have a runner who we go through the office throughout the day, wiping areas down, surface down. And so that's another reason that we have all the sanitizing liquids and disinfectant sprays. So, my hands are raw.
I know. And that kind of ties back into, Todd's practical considerations. These are excellent points. You want to make sure that you do facilitate all of this. But one thing that I've been telling everyone, the key to all of this is to communicate. You want to make sure that you have a plan before you bring people back in. Don't be scrambling, trying to figure out how this works. Create an action plan, or your COVID-19 response plan, and what the expectations are regarding social distancing, PPE. So your employees know, what are you going to do when somebody tests positive? What are their expectations? What if one of my coworkers gets COVID? How am I going to be notified? What if I get COVID? What's going to happen to me? So really addressing all of those key things in a plan that you can communicate to your staff, and then communicate updates is a solid best practice.
And that's when I mentioned we sent out an email to our staff, making sure the area that they work in, please make sure they wipe those areas down, whether they, contacted the whole area or not, just being conscious of making sure the area is safe for everybody, and you're washing your hands constantly. So those are the things those are our expectations of the support staff and the attorneys. And that's what we're trying to implement and maintain in our office.
Yeah.
We have another question from a viewer, and I think it has to do with the daily health checks. The question is really, would it be appropriate for attorneys or staff at the law office to say, in effect, if I've come in I've met the standards. And so, and they'll say that in advance so they wouldn't have to send the information in daily. And then the employer would just take an audit of who's in every day. Todd, what do you think about that approach?
I think so. I think you have to do a lot on the front end about giving that expectation to every employee. I would want them to sign and date that, here, I understand I have to do this every day and agree I will do this. And if I come in, then my presence is indication that I, can say no to all of these questions, including that I don't have a fever, and have that for each person on file. And then periodically audit that by having somebody just check with somebody, hey, just wanted to make sure you're okay today. You can't answer no to all these questions. That you can keep some records of that, just that you audited it and yes, they said no, without getting into keeping medical records. And I think that could be important down the road for workers' comp claims, for lawsuits, all kinds of fun stuff, or just enforcement by either the health department or OSHA. So I think you could do that, but on the front end, you'd want to document what exactly you've told every employee that they have to do it, and you've got something signed that, like, hey, if I come in, this is what I'm saying. And I think probably the smaller the organization you are, the easier that is to do. Your managing partner or the office administrator can walk around, just kind of eyeball everybody how they're looking, make sure nobody's not in their office by themselves coughing up a lung or something.
Right.
And with the sinus season going on, it's really difficult to maintain, who's sick, who's not, why you have a fever. So that just adds to a lot of things. Will it be okay to just do one-page list with everybody's name on, and you've gone through the questionnaire verbally or however, and then just keep that log of all your employees daily?
I have a client that's doing that. They're keeping a log. So they have the questionnaire and that they're asking, including the temperature, but then they're logging whether or not they assess that employee that day.
I think that's a good way to do it.
And everybody's name on the same log, and just verifying that the questions have been asked.
That's correct. And that way, the documentation burden is less, because you don't have all of those individual pieces of paper that you're going to have to keep track of, B, you're going to have to make sure you have space for as long as this goes on, and keep secure. So, yeah.
And a suggestion from one of our viewers regarding the use of disposable coffee cups, flatware, not offering clients or employees shared coffee mugs, not having the shared coffee or water pitchers, maybe going to bottled water instead of the water cooler, that sort of thing.
100%.
Yeah. All right. Well, we're pretty much near the end of our time, but I do want to ask if all the panelists will stick around, and we're going to get a photo so we can document this for social media. And then I also wanted to mention that at the conclusion of this, we will be placing Todd's PowerPoint presentation and the resources that Gladys has collected for us on our website. That's www.lubar.org. We've got a page dedicated to COVID-19 issues, and one of the tabs on that page is entitled Attorney Resources. So that's where you'll find this information. And then I would also ask if you have any suggestions for additional programming that you'd like to see us provide to you, practical stuff. We're going to be doing one again, like I said, next Tuesday, May 26th at 2 p.m. on the impact of operations in district court with a group of panelists. And all of the previous webinars that we've done regarding trial courts, appellate courts, family court, all of those things can be found on our website. So with that, unless there's any concluding remarks from any of our panelists.
Todd, do you have a one-page checklist of the questions that have to be asked daily?
Yes, and I think it's in the executive order as well. If you go to Healthy at Work, you get the executive order, and the minimum requirements page, they list what you need to do.
Mm-hmm. And we'll find that and include that in our resources that you can find on our webpage as well. Okay. Well, with that, I want to thank all our panelists and also all of our virtual attendees for being with us today, and watch eBrief, which will come out later today. Comes out every Tuesday afternoon. Go online to our website. We'll continue to offer these sorts of resources. And as Governor Andy says, we will get through this. We will get through this together. So I'm not going to do the sign language, but you get the gist. So thanks with that, and we will conclude our meeting.
Thank you. Stay safe.
Thank you. Stay safe.
All right, hang on, panelists. Yeah, maybe better because it's going to take me. Hang on just a second. Oh, let's do, I don't know, expand this. Okay, here we go.
How do you do this so I'm not here? Thank
Okay,
you.
thanks everybody.
Thank you.